Defenses in medical malpractice cases. What is the doctor going to say to try to get out of responsibility? Hi, I'm Joel. This is Mark. Welcome back to the Williams, Elleby, Howard, and Easter YouTube channel. That's what we're going to talk about today, is the most common defenses that we see when we bring medical malpractice cases. So you want to jump into number one, Mark?
Yeah, well, I always think when I sign up a medical malpractice case, the way it's going to go is they're going to say, we didn't do anything wrong. Even if we did do something wrong, it didn't cause any harm. Even if we caused harm, the harm wasn't that great. And even if the harm was great, it was somebody else's fault. That's kind of the way it goes in these cases.
The end in the video, exactly.
Right? And more defenses come up in medical malpractice cases than I see in any other kind of case. And the first one would be, we didn't violate the standard of care. And the standard of care is what a reasonable doctor, nurse, healthcare provider would do under the same or similar circumstances. And what always happens in these cases is that the provider will hire experts who look smart, act smart, and say all the right things to say that this was excellent care. Mm-hmm. And one of the ways, of course, we go about attacking that is to see, what does medical literature say about what these experts come in and are talking about? Yeah,
the literature that's written by respected physicians around the country before this happened. So this is what the standard of care is, as opposed to a hired gun expert that looks at the situation and then tries to mold their testimony to make it seem like what happened was okay.
Yeah, in fact, I had a trial once where an expert for the defense came in and started saying that the standard of care had not been violated, and he had actually written a textbook in the past that said the exact opposite thing.
That's right. The second defense that we see a lot is causation. And by causation, it's typically the third element that we have to prove in any personal injury case. We have to prove that there's a duty to do or to not do something, that that duty was breached, and that the breach of that duty caused the damages. So the third element there is the causation. So basically what you'll run into a lot is the doctor will say, well, we didn't do anything wrong, but if we did, it didn't cause this injury, or that condition or that injury was unavoidable. It was going to happen anyway, right? So we then have to figure out, all right, well, how do we link up the action or inaction by the medical professional to the injury that was caused? And that's the causation element. But a lot of times I'll say, even if we did do something wrong, it didn't cause what you're claiming it caused.
Yep, and a good example of that might be in a delayed birth case where signs of premature birth were there and the doctor didn't recognize them, the baby's born early. They might say, even if we should have recognized these signs, there was nothing we could have done about it. The baby was going to be born no matter what medications we gave, no matter what steps we took. The baby was going to come early regardless of what we did.
Yep. The next defense we see a lot deals with the fourth element that we have to prove, and that's damages.
Yeah, and damages are huge in a medical malpractice case. And if you've watched any of our other videos, you know that we say, unlike a car wreck case or something, just in order to bring a med mal case, you got to show that the damages are really life-altering. Mm. And so what the defense typically will say is, any damage we caused wasn't that great. And they know that lawyers like us looking at a case who might have to spend $100,000 or more to bring it to court might not be interested in a case if the damages are so minor that the cost benefit isn't there.
Yeah, and I want to address one thing too about this, because we get a lot of comments on this on some of our med mal videos, is, you know, people being very frustrated that it's not fair, or something like, well, only the rich or the powerful or the people who have those life-altering injuries, so they're the only ones that have claims. Yeah. And do we agree with that? Do we like that? No. It's just the reality of the situation that we're in, and we never want to give any of our clients or any of our viewers false hope about what the cases require.
Yeah, and it isn't fair. And I don't like it. And I have conversations with people all the time about something bad that's happened. But just because, let's face it, the deck is stacked against the patients in medical malpractice cases, because the people who pass the laws have made it very, very hard to pursue these cases, and very, very expensive. And so, yeah, it isn't fair. We don't like it, but we're shooting straight when we say it.
Yeah. So that, speaking of writing the laws and the deck being stacked against you, one almost silly defense or one silly way that doctors can get out of things sometimes is, in Georgia, we call it the apology statute. So the way that that works is literally if Mark is my physician and Mark does something that, if he commits malpractice and does something that hurts me really bad, he can come in and say, Joel, during the surgery, I had a bunch of beers and, I'm sorry, I cut the wrong thing and, you're paralyzed. Well, if he does it in a way to apologize, that's not admissible at court.
Yeah.
And everyday people, like in a car wreck, if you run a stop sign and you jump out of the car and you run up to the person you hit and say, I'm so sorry, it was my fault, I ran the stop sign. Well, you don't get the same protection the doctors get because the laws are written in their favor.
That's exactly right. In 2005, the legislature passed what they called tort reform, which again put a lot of hurdles in the way of a medical malpractice case, and that apology statute is one of them. You could say, I'm at fault. I committed negligence. I committed malpractice. And a jury will never hear that.
Yep. They dress it up and make tort reform sound like a really good idea. And then when people are faced with a situation where they need to bring a claim, they realize, you know what? It's not such a good idea because it hurts everyday people and protects people who make mistakes and hurt others. Another defense that we see a lot is assumed risk or known risk of the procedure.
Yeah, an assumed risk or known risk of the procedure may be that when something bad happened, this was just something that was possible and it was going to happen anyway, and therefore the doctor is not responsible for it. One of the ways I like to attack that is if it's a known risk, then you should be on a heightened level of scrutiny and take extra steps to prevent that known risk. But they may point to a medical article that says something like 5% of all these cases go the wrong way, and that they'll attach their defense to that.
Yep. Another defense that we see a lot is when the defendant attacks the plaintiff's experts. There are laws that are written that require experts to have certain qualifications. So you not only have to be qualified, but you also have to use certain methodologies to reach your conclusions that are accepted within the profession. You can't have too great of what we call a gap between the methodology that you use and the ultimate conclusion that you come to. So there's a lot of different ways that the defense can attack your expert, and we can also attack the defendant's expert that way. But the thing is that if the defense is successful in attacking one of our experts and getting them excluded, that could mean that the whole case goes away because that element of the claim is supported by that expert's opinion. And without that expert's opinion, the one block in the puzzle may not be there, and then the whole thing fails.
You have to have an expert to pursue a medical malpractice case in Georgia, and if you just, like Joel said, pull out that one block, the whole house of cards could come down. Mm-hmm. What's crazy to me is when the laws were passed in 2005 limiting expert testimony, they don't apply in criminal cases, these expert rules. So if a prosecutor, for instance, wants to send someone to jail for life and has to prove their case beyond a reasonable doubt, they can hire any old expert they want. But in a medical malpractice case, where trying to just prove more likely than not, we have to have an expert who complies with a whole bunch of rules that don't apply in criminal cases.
Yep. Another common defense we see comes up in situations where there's emergency care that's being provided to a patient. A lot of times that happens in the ER. It doesn't have to happen in the ER. It could be an emergency that occurs while someone's hospitalized. But in Georgia, there's a different standard that the plaintiff or the injured person has to meet in order to be successful in those cases.
Yeah, that standard is gross negligence. And if you think about it this way, regular malpractice is I committed negligence. What a reasonable doctor or reasonable nurse would have done, I didn't do that. But gross negligence is even if I committed malpractice, I'm immune from a lawsuit unless you can show what I did, even a careless doctor wouldn't do. Mm-hmm. And that's a higher standard. Also, the burden of proof is higher in emergency room cases. More likely than not is what we typically deal with, but in an emergency room, we have to prove a case by clear and convincing evidence.
Yeah, and that may not sound like a big deal to some people because really, like, a lot of people view the world as, well, right is right and wrong is wrong, and you either do the right thing or you made a mistake or you did something wrong. But it's a big deal when it comes to what the thresholds that the law requires you to meet. Another defense that we see goes along with procedural requirements of bringing the claim itself. So there are a lot of little silly rules, like in Georgia, if you bring a medical malpractice case, you can't write into the complaint that we're claiming $5 million in damages, right? It just has to say $10,000. Little things like that, that if you're not familiar with these type cases, you could miss one little procedural aspect and then the whole case gets tossed. And then you're back to square one, starting all over. So those little procedural things just sort of emphasize why it's so important that when you're going to bring a medical malpractice case, the attorney you hire should be familiar and experienced in those cases and know the local rules for your particular jurisdiction. My least favorite defense that I have to run into a lot is the point the finger defense. So a lot of times when you see a medical malpractice case, you would think, okay, well, it was Dr. Smith made the mistake during surgery, so we're just going to sue Dr. Smith. But the reality of it is that there is an entire care team, there are corporate entities, there may be follow-up, there may be doctors that deal with the follow-up care, there may be primary care physicians that are seeing the patient after they're released from the hospital. So the negligence and the harm could be spread out. The negligence could be spread out amongst multiple people. And typically what you're going to see is you're going to see the surgeon may say, well, the ER physician didn't tell me about something I needed to know, or the radiologist didn't get me this in time, or the lab didn't get me the blood work in time, or yeah, maybe I made a mistake during surgery, but when the person got out of surgery, these other doctors didn't do their job properly to identify that a bowel was nicked or something like that, and that's what caused the harm. So even if I did mess up, it was somebody else that caused the harm. And so a lot of times you think it's just going to be, you know, Mark versus Dr. Johnny, when it's really Mark versus Dr. Johnny, 5 nurses, 7 other doctors, and, you know, a partridge in a pear tree.
Yep, and in hospital cases, that's particularly important. I'm thinking of a case I have right now where we had to sue 13 different defendants because in Georgia, there's something called apportionment where, like Joel said, they can point the finger, and then at the end of the case, the jury can say, well, 10% was due to this one, and 20% was due to that one, 30% was due to this one. If you don't sue the right party, you could have a verdict in your favor that you can't collect on because it's all the percentages are against people who you didn't bring into the lawsuit. So especially in a hospital case where the radiologists, the emergency room, the nurses, the doctors may be employed by some other company altogether, you kind of have to look at everybody, sue them all, and then figure out who's the right party as the case goes on.
Yeah. And practically speaking, the lovely result of that is you will have, as the plaintiff, your lawyer or their law firm versus 10 different other law firms, and probably 2 to 3 lawyers from each of those law firms. So it's literally you versus, it's David versus Goliath, is what it is.
Absolutely.
So you better make sure that David knows how to use that slingshot and aim it the right way to make sure that you're going to be successful in your case.
Yeah, and an important point on this is if you think you've had a medical malpractice case that you might be interested in pursuing, it's super important to get it started early and go see someone early, because not only is there a 2-year statute of limitations in Georgia, but if you don't know who the proper party is and you come to a lawyer at the last minute, that lawyer might not have time to figure out who all the right parties are and only find out when it's too late that there's someone that should have been brought into the case.
That's right. Another common defense that we see, and then we'll wrap this up, is what we call contributory negligence. And this basically goes to, the most common example of this would be a patient not complying with the doctor's order. So the doctor may make a mistake, but then tells the patient, we need you to do A, B, C, and D as follow-up on this procedure. And those follow-up things may be correct and the patient needs to do them, but the patient doesn't do it. For example, maybe after a spinal surgery, if a patient is a smoker, after a spinal surgery, the doctor may say, you have got to not smoke because the healing process is not going to be like we want it because of the chemicals that are in the cigarettes or the cigars or whatever. And then the patient goes out and continues to smoke and the healing doesn't happen properly. Well, you can understand why that would be a good defense in a case like that.
Yeah, sure. And the defense lawyers love that word non-compliant because it just sounds really bad. And it might be that in a case, let's say after surgery, someone is supposed to go to physical therapy. They may be going to all their appointments, but miss one or two because they had to pick up their kids from school, or they just weren't feeling great and had to miss an appointment. And of course, they'll call that non-compliance because it just sounds bad and make it look like if only you had complied, you would have gotten better.
Yeah. So to keep this video from being an hour and a half long, we will wrap it up here. But as you can see, there are tons of defenses that you can face. You may face them from multiple defendants and all of that, but you just have to make sure that you cross all your T's and dot all your I's and you understand the challenges that you're going to face if you go to bring a medical malpractice case. This video is not to discourage you or say that these cases can't be successful, because they can be successful. They just take a lot of work, and they require the knowledge and skill of good attorneys to handle them the way that they should be handled. So, but we hope this video has been helpful to you. If so, give us a thumbs up, hit that subscribe button. Otherwise, we will see you next week.